Yes, Mr. Hunter.
Thank you, my lord. I appear on behalf of the appellant, Mr. Williams, to my right, on behalf of the Secretary of State.
I can tell you that we have read Mr. Parsons' two decisions. We've read the judge's judgment and we have read the skeleton arguments. So we have the points and you can take them shortly.
I'm very grateful. My lord, I'll start with, if I may, the issue that you identified in granting leave to appeal as being at the heart of this appeal, namely the decision maker, Mr. Parsons' reliance or characterisation of the council's reliance on its expert as unreasonable, and that raising an important point of principle, namely the responsibility of a party for the evidence of its expert. And if I may, before I turn to the facts and the grounds and the law, I will just make 5 brief points by way of introduction and then come back to them at appropriate points in my argument. So I'd say this first of all. Although the strict rules of evidence do not apply in planning inquiries, that is common ground, and the authority for that is Wednesbury, which is my learned friend cites. Experts in such proceedings still owe the same overriding duty to the inquiry that is owed to the court in civil, criminal or family proceedings. Yeah,
that's in the Planning Inspectorate guidance for experts.
Absolutely. It's in the Planning Inspectorate guidance, the PEPA good practice memo, and in the RTPI advice to on expert witnesses. And my lord, if the court has that, I possibly don't need to give you the references, but I have them if it would help.
So you would say that the principles in Icarian Reefer apply to planning inquiries just as much as they do to civil proceedings?
I would, for that reason. I would note, I have to, in fairness, note that the PEPA good practice guidance issued by the relevant Bar Association notes that it has never been held that that is the case, and so is cautious about saying that they apply. But I would submit it follows from the fact that there is the same overriding duty that the same principles should apply, yes. And the second point that I make is this, that it follows from that, that whatever responsibilities that a party calling an expert may be said to have in planning proceedings, they must be consistent with that duty. There is a relationship between the two, and certain things are ruled out as a result of the nature of that duty. And in particular, what the council says is that a party cannot be identified with or be held to have absolute responsibility for anything that its expert witness says or does, because that would be antithetical to the expert's duty to give independent, objective evidence and so forth. And so we say the position in planning is the same as was identified by Lady Justice Sharp in the Aylesbury DPP and Aylesbury Crown Court case, Authorities Bundle 7 page 121 para 20. It's the same in planning as in criminal proceedings. The third point I would make is that there is no authority, policy or guidance which supports the proposition that a party in planning proceedings has a duty or responsibility to ensure that the evidence given by their witness withstands cross-examination to any degree. So my learned friend draws a distinction between it not being unscathed and it suffering a more fundamental reverse. The fourth point I make is that to impose such a duty would be inconsistent with the fundamental rule of the planning costs regime, that costs can only be awarded if a party itself behaves unreasonably and thereby causes another wasted or unnecessary expense. It has to be the party itself that behaves unreasonably. That is clear from the terms of the guidance. And the fifth point I make, and the final one at this stage, is that aside from that, it would also be irrational to hold that parties have such a duty, because no parties can guarantee that their experts will come up to proof or will avoid making damaging or potentially fatal concessions in the course of cross-examination. And that is particularly so in light of the absolute prohibition on advocates coaching, practice or rehearsing in respect of a witness. They cannot do a dry run to see how the expert will perform under fire. They can do lots of other things. There is no dispute about that. They can give assistance. They can pose questions, suggest topics, indicate the proper parameters of the evidence that they should give, but it can't test how the witness will perform under fire. So having done that, if I may turn to the facts, and I'll be as brief as possible, but there are certain facts that I would wish to highlight. And if I could start, my lords, my lady, with the chronology in the core bundle at page 14 in the Arabic numerals. So I think the courts have the paper bundle, so I will stick with that numbering.
14?
There should be an agreed chronology.
No, my pages have gone a bit awry. I think that it's page 14 once you get past.
Yes, there is the skeleton argument.
36 pages, which are little Roman numbers.
My Lord Coulson has it exactly. So it is
Yes.
actually the 39th page sequentially, but for the reasons given by my Lord, it is numbered 14.
Oh yes,
It is tab.
I've got it.
And the court will note that in the second row there, it was noted that the claimant had consulted with the council had consulted with the HSE in this case, and who had objected due to the site's location in a consultation zone around the Runcorn chemicals complex. It can be seen from the HSE costs application that the complex has hazardous substances consent for, amongst other things, significant quantities of chlorine. Again, this is not a matter of dispute. The inner zone, this is not explained in the evidence, but if the court wishes to know what that means, I can provide an explanation for that.
Well, I'm a bit wary
Yeah.
of going into material that is not in the two decisions. And we do know that Mr. Parsons knew and said that HSE had objected, and he found that despite HSE's objection, it was not unreasonable for the planning authority to resolve to grant the planning permission, and he rejected Viridor's argument that the objections were overwhelming.
I'm grateful, my Lord. I can take things briefly then. My Lord, what we can note is that the fundamental dispute was over between the HSE and the council, and the reason that the council led on this rather than the applicant, rather unusually in a calling case.
The developer said, I don't know anything about it, it's between the council and HSE.
Yes, but this is in the documents. My Lord, if the court goes to the supplementary bundle, page 23, paragraph 7.2 of the...
23, you say?
It's the numbered page 23.
Yeah.
Yes.
Yeah.
In paragraph 7, subparagraph 2, the court will see there what Mr. Hopwood's advice to the planning authority and his original evidence was said to have been, namely that the planning authority's criterion, which was set out in its local development plan, statutory development plan, and which, as was noted there, it was common ground would not be exceeded at the proposed development, was a 10 chances per million risk of fatality. And Mr. Hopwood said that was within the bounds which would be deemed tolerable, having regard to even the HSE's own risk tolerability framework. Furthermore, his advice and evidence was that the estimated risk of injury and fatality at the site, very small as it was nevertheless likely to be overestimated by the HSE, that is, due to the fact that there had been major changes to the infrastructure of the chemicals complex since the risk assessments on which the HSE had based its consultation zones, and the inner zone in particular in this case. There have been major changes in the near 30 or around 30 years since the risk assessment was originally carried out. And so Mr. Hopwood's primary position in his advice and his evidence was that the HSE's consultation zones were out of date and not a reliable or accurate basis for decision making, and that the risks in this case were tolerable even on the basis of the level of risk assessed by the HSE.
The document we're looking at is your response, or the council's response to the application for costs.
Yes.
So this is a document that was before Mr. Parsons.
It was before Mr. Parsons. So there were three responses. There was, well, if I go through the documents, there was the HSE's application for costs, Viridor's application for costs, responses to both of those from the council, and further submissions by HSE and Viridor, to which the council only responded to the HSE's, which was in the bundle. So I said the issue for the council was whether or not the application should be refused or opposed, notwithstanding that it accorded with its local policy. This is again in the documents. I will direct the court to where you can find it. Notwithstanding the HSE's objection, because, as the court will be aware, there is a statutory presumption in favour of the determinations made in accordance with the development plan, and the issue is whether the objection was sufficient weight to outweigh or rebut that presumption, and that can be seen at document SB2, which is the council's original response to the HSE's application for costs, page 6, paragraph 33, Roman 1.
So we're still in the supplementary bundle?
It's still in the supplementary bundle. Yes, my lady. Page 6, para 33, Roman numerals 1 to 5, if I could leave the court to read that.
Sorry, the numbering's gone wrong again.
I'm sorry, I beg. That is my error, my lord. It's page 15. I'm reading.
Page 15.
I beg your pardon. I'm reading the internal numbering of the document.
Aha, yes, page 6 and 15.
Page 6 and 15.
And it was Roman numerals
1 through to 5.
Thank you.
Yes.
So the argument being put in response to the council's in response to the application cost by the HSE was that the council was entitled to conclude reasonably, as a matter of planning judgment, on the basis of Mr. Hopwood's evidence, that there were such issues with the HSE's advice and the status of the development plan policy, the fact that it had been through 2 public examinations, meant that they were entitled to rely on its evidence. It was reasonable for them to rely on its evidence. Yeah. And a distinction is then drawn in both sets of submissions, as the court will have noted, I think, that between the council never having any reasonable basis for relying on it, and then determining that it could no longer rely on Mr. Hopwood after he'd given evidence in cross-examination. That was the argument. I would like to go back to the HSE's cost application, though, so the court can have some flavour of what it was that Mr. Hopwood conceded in cross-examination, or was said to have conceded by the HSE, and it wasn't disputed by the council. What then was the difference with his written evidence? So, if the court could turn to the supplementary bundle, tab 1, page 1.
Yeah.
Paragraph 3. As my Lord Justice Lewison has already noted, the application was made on the basis, not on the basis that it was eventually awarded, but on the basis that the original resolution had been unreasonable, and on other matters, including an alleged failure to review and adjust the council's position.
Yes.
The paragraph 7 at page 3 in the bundle, the summary of the position there makes clear that what the HSE was saying, this is the penultimate bullet point, that he had agreed the key elements of the HSE's case, and the upshot of that was that he said he would have advised strongly against the grant of planning permission if he were in the inspector's shoes, and that resulted in the council withdrawing and so on and so forth. If the court could then turn to paragraph 19 on page 8, we can see a bit more, see what is being said a bit more precisely and what led to that final, and we would say the fundamental concession. So, as it says there, the answers in cross-examination of Mr. Hopwood showed the local policy relied on by HSBC failed to follow the principles in the planning practice guidance, and when the planning practice guidance principles were followed, the outcome was to strongly advise against the planning permission. So, in short, it can be seen that what the HSE was pointing out was that Mr. Hopwood had answered questions not on public safety or risk or the matters which are identified in Council's submissions as being in his evidence, but on matters of planning policy or guidance. And that the answers given to those questions on PPG principles were what led to him having to concede that he would advise against. What the Council's position is that it was reasonable, clearly, for Mr. Hopwood not to deal with those matters in his evidence because he was not a planner. And Mr. Gibbs, as is noted in the again in the Council's response, it was Mr. Gibbs that was giving the Council's evidence on planning matters.
Well, we don't know what happened in this closed session, but I take it there was no objection to these questions being put to Mr. Hopwood.
Well, there was an objection, but the inspector allowed the questions to be put and said deal with it in re-examination. So what I would note, however, is that when comparing what the HSE say was conceded, and so we accept that was conceded, there was no suggestion that he had recanted his evidence regarding tolerability of risk. So there's no reference to him recanting that, or his opinion that the HSE had likely overestimated the risk, or that the consultation zones were out of date. So there's no suggestion that that part of his evidence didn't stand up to scrutiny in whatever sense. Rather, the fundamental point was that he had accepted the HSE's case on the principles in the PPG, and that led to him making the major concession he made at the end. And I think the court is aware what happened after that. The Government Legal Department wrote the same day, advising that the council should consider its position and it couldn't reasonably continue to support the application, and the council decided that that was correct and withdrew, and the other consequences followed. Can I just note one other document before I turn to the grounds? Sorry, one other reference within the same document. Tab 2, response to the HSE cost application on behalf of the council. If I could go to paragraph 35, Roman.
Sorry, page.
Page
16 and 17.
16, yes, over 16 and 17.
Yeah.
I mentioned earlier on that the HSE alleged that initially that the council had failed to keep its case under review, or failed to review or adjust its case. This is the response to that. What was pointed out in particular was it had been kept under constant review. Multiple conferences had been held involving council, Mr. Hopwood and Mr. Gibbs before and crucially after the exchange of evidence, at which the merits of both the HSE's and the council's positions and the evidence were discussed extensively. So the important point, note that, was that the council was making clear that it had considered with Mr. Hopwood the merits of the HSE's evidence and his own evidence in light of that, and there was subsequently no attempt to dispute or rebut that. No claim that that wasn't actually what had happened. And indeed, again, as the court will be aware, the judge, initially the council's case, or in the court below, the council's argument was that Mr. Parsons appeared to have found, contrary to that, with no evidential basis, that there had been a failure to keep the case under review or to continue to appraise it. The judge dismissed that ground on the simple basis that he did not find that that was what was implied by Mr. Parsons' reasons. So we are content with that. We're content to proceed on that basis, that there was no finding to that effect. If there had been, however, we say there would have been an error of law because there was no evidential basis for rejecting the council's position on it. So, my lord, my lady, I don't intend to deal separately or at the outset with the cases. I don't think it's this kind of case where it's necessary to go through the authorities separately and then proceed to the grounds. I will pick up the authorities as I go along, if I may, unless the court would like me to take them and deal with any particular authority in advance of that.
Well, there's one authority which I'm not sure I quite understood. I just wondered whether something's gone wrong in the transcription. And that is the decision of Mr. Justice Jowett. Which one was it? It's tab 4 of our authorities bundle, Crown and Secretary of State for the Environment. And he says on page 56 of our bundle, after referring to the Chichester case,
Yes.
he says right at the bottom of the page, there is thus an evidential threshold which, if reached, is unlikely to put a planning authority beyond the risk of a finding that it has been guilty of unreasonable conduct. That must mean likely, must it?
I agree. Yes.
For what it's worth, my lord, I entirely agree that
is.
You agree with that?
I agree, my lord, I was going to make the same point.
Yeah. It must mean that, and yes.
I'm glad my daughter's raised that, because I must say when I read that I thought, can that be right? And then I thought, well, maybe it's some sort of planning gloss that I'm not.
I think planners are much more simple than you give them credit for.
That was the only question I had on the authorities, so we'll carry on. I'm
grateful then. So if I turn to the first ground, irrationality. I'll start with this. As I said earlier, the Secretary of State's overarching policy is that costs will only be awarded where a party behaves unreasonably and that causes unnecessary or wasteful expense. That obviously means it is a fault-based jurisdiction. The point I would emphasise again is that this has to be the fault of the party. And if I could just take the court to the wording of the PPG to make that clear. So that is paragraph 30 of the PPG, tab 12, supplementary bundle, page 92.
Sorry, I'm page 92. Oh, wait a minute, I'm looking at the wrong bundle.
This is under the rubric in what circumstances may costs be awarded.
That is correct, yes.
And
Yes.
again, this document is guidance on appeals.
It is the guidance issued by the Secretary of State on costs. It was, as my learned friend noted in his skeleton argument, it was briefly set out in various circulars that are referred to in Chichester and North Norfolk and Wakefield, but it's now been replaced by this. This is the source of the cost guidance. But that principle has remained the same throughout all iterations of relevant policy as far as I'm aware. And I would just highlight, perhaps without going to the authority yet, that the point I make that it needs to be the party, the paying or proposed paying party that has behaved unreasonably, not anybody else, is even clearer in the wording of the PPG than it is in the case of the regulations on costs in criminal cases under Section 19 of the Prosecution of Offenders Act, because that refers to costs recurs to acts or omissions on behalf of the relevant party. And yet in Aylesbury, Lady Justice Sharp held that could not be applied to an expert. It's even clearer here in my submission.
And the Secretary of State's statutory power is to award, make an award as to the parties by whom costs are to be paid. So there's no equivalent in planning of, for instance, a wasted costs order, which could be made against legal representatives or indeed against experts.
That is correct.
I think it's section
250, sorry, yes.
250, subsection 5 of the Local Government Act 1972 as applicable to calling inquiries.
Yes.
So it's the statutory power is limited to making orders against parties.
Yes. Yes. The test, the decision, the decision to make it a fault-based jurisdiction based on unreasonableness is in the guidance. But the power is wider, but that is what the Secretary of State has decided to do. And it is common ground that the basis on which the costs were awarded to both interested parties in this case was that the council's unreasonable conduct was in the form, or was the reason for the form of the council's unreasonable conduct was not withdrawing when it did. That was the wording of Mr. Parsons in paragraph 17 of his decision. I'm sorry, I beg your pardon. Paragraph 20.
Page.
That is page 189 in the core bundle.
Thank you.
So it is the third line, the sentence beginning in the middle of the third line from the bottom.
Yes.
And it's also clear from the Viridor decision letter, page 193 in the same bundle, paragraph 12 at the top of the page. I'm sorry, I beg your pardon, paragraph 11 on the page preceding that.
In the Viridor decision?
In the Viridor decision. Paragraph 11, Mr. Parsons identifies the main decisive issue, whether or not the council acted unreasonably by withdrawing their support for the planning application at a late stage in the call-in proceedings, causing wasted expense. And then, for completeness, paragraph 18 in his conclusions, paragraph 18 and 19 in his conclusions make clear that he concluded that the council had acted unreasonably in not withdrawing earlier. And that is, of course, reflected in Mr. Justice Fordham's judgment. That's paragraph 15, page 26 of the core bundle. If the court wishes that reference. But what was controversial between the parties in the costs applications was not whether it was reasonable for the council to withdraw, as I've indicated to the court. Everybody agreed the council should have withdrawn following Mr. Hopwood's evidence. The question is solely whether it should have done earlier.
It was agreed that the withdrawal at the time it was withdrawn was not unreasonable.
Yes, it was the failure to withdraw
Which makes
earlier.
the language at 20 very odd. So page 189.
Yes.
The decision to withdraw their support for the application when they did was unreasonable.
Yes,
it wasn't.
No, and this was addressed by Mr. Justice Fordham, I think, who has alighted on the same issue with the language, I think, which he says in one sense it will always be unreasonable. There's a discussion of that. But it's clear when one reads it in context, and I say that what was being said, in particular by Viridor rather than the council, the HSE, because the HSE was saying that the council's support was always unreasonable. That Viridor was saying, and Mr. Parsons accepted, that it should have been withdrawn earlier. So although the language is infelicitous, that is the sense, and I think that is common ground, and as I say, it was the basis on which I understand Mr. Justice Fordham made.
There's no doubt Mr. Williams will explain how we reconcile what Mr. Parsons says in paragraph 17 of the HSE decision. It is undisputed that the council decided they could no longer support the application in the light of the evidence heard in the closed public safety session. And what he says in paragraph 20 is evidence there had been no material change in the evidence.
Yes. Well, Well,
Myself,
well,
myself find those two statements very difficult, if not impossible, to reconcile. It was the evidence that Mr. Hopwood gave was the very reason the council withdrew.
well, my lord, precisely, and that was the point we made below, and the material change was in Mr. Hopwood's evidence. The difference between what he had said in his written evidence and his advice, and what he said in court, and so that is part of what I will go on to say was the irrationality. He overlooked the factor that he had identified as a relevant factor in deciding whether or not there had been good reason or reasonable grounds for the change of position. And he failed to understand that the volte face was that of Mr. Hopwood, and that was what led to the council having to change its position. But yes, I will come to that. I had noted here, and I will make the point, although I think that again the court has it, as pointed out to me, that paragraph 15, the decision maker decisively rejected the HSE's argument that the council's position was inherently unreasonable, and indeed it is noteworthy that he goes on to say, in the absence of a formal decision, he can't even conclude that the application might have been successful, notwithstanding what happened with Mr. Hopwood. So he's acknowledging there that there was no, or he had not been able to identify any intrinsic unreasonableness in the council's case, and could not say that it was as inherently unreasonable. The judge, in terms of what how the judge explained Mr. Hopwood's, sorry, I beg your pardon, Mr. Parsons' characterisations of the council's alleged unreasonable conduct, he gave two principal explanations. The first one I would take the court to is right at the end of the judgment. So this is Core Bundle, tab 6, paragraph 43 on page 38 in the numbering in the right-hand corner at the bottom. He says this in relation to the application for permission to appeal, the reasons he refused. This is 6 lines down, midway along the line. The primary decision maker's evaluative judgment, which I've held to be within the range of reasonable responses with adequate reasons and no demonstrable flaw, was that the council's unreasonable action lay in its failure to ensure that evidence put forward was capable of standing up to scrutiny. What that appears to be saying is that it was the council's failure to ensure that the evidence did stand to scrutiny, whatever that meant. That meant it had acted unreasonably. But I would also note what the judge said earlier at page...
In relation to that point, you say that's simply too high to say to ensure that evidence put forward is capable of standing up to scrutiny.
Yes, I said that is irrational, both because it's inconsistent with the cost guidance and because it's an impossible standard to impose as a general rule.
Yeah.
The
second point was?
The second point is on page 33, paragraph 31. And this is in the context of the ground which related to the keeping under review point. He says that the decision maker's point was, which was about one of several aspects seen as counterability, all of which were relevant features considering the collapse, whether the withdrawal was out of good reason. To the decision maker, the proof of the pudding was in the collapse in light of the responsibilities in the absence of any other change. I mean, the metaphor makes it a little unclear, but he's either saying the same thing there that he was saying, appears to be saying in paragraph 43, which is the council, Mr. Parsons considered the unreasonable action was the failing to ensure the evidence put forward was capable of standing up to scrutiny, or he may be saying that Mr. Parsons took the fact that there had been a collapse and no other change other than Mr. Hopwood's evidence to be sufficient reason to be the proof of the pudding that the case collapsed and therefore the council must have done something wrong, which we say is also irrational because it has a logical gap in it, in particular that it fails to know the other reasons why a case or a witness may make concessions which fatally undermine their party's case, of the sort that were discussed by my Lord Justice Coulson in Cornish, and the ones that were actually advanced by the council in this case, which was that it was the witness had been subjected to a skillful cross-examination, points were put to him that couldn't be reasonably anticipated given the scope of his expertise, and he'd given unfavourable answers. But that wasn't the fault of the party calling him. So he doesn't consider that at all, and as going back to the point my Lord Justice Lewison made a moment ago, he doesn't consider specifically the fact that he's already noted that it is accepted that the fundamental change that resulted in the withdrawal was Mr. Parsons' evidence. Sorry, I beg your pardon, Mr. Hopwood's evidence. So I will, if I may, I will deal with it on both of those potentially alternative bases. I'm going to deal with, firstly, whether it was irrational for the decision maker to find that the council had a duty to ensure that Mr. Hopwood's evidence was capable of standing up to scrutiny and cross-examination, and then whether there was a logical gap or reasoning insofar as he held the proof was in the pudding, or as I think the decision maker put it, that it was difficult not to conclude that the situation was of the council's own making. That's the L20. So, as I said at the outset, there is no, dealing with the first one, was it irrational to find that such a duty existed? There is no authority or guidance which supports the proposition that there is such a duty. My learned friend refers to, I don't think my learned friend says that this imposes such a duty, but he says such a duty is consistent with this. He refers to the PPG paragraph 28, which is at page 91 of the supplementary bundle, I believe. So, if the court has that, in the second bullet point, you can see there are three, or the 3 bullet points set out the aims of the costs regime. The second one says, after a reference to exercise and development management responsibilities, the aim is to encourage authorities to only rely on reasons for refusal which stand up to scrutiny on the planning merits of the case. I would note 2 points of that. First of all, this is an aim, and I'm going to take the court to the actual policy that implements or seeks to achieve that aim, because obviously the two go hand in hand. But sticking with the aim at this point, the aim is to ensure that reasons for refusal stand up to scrutiny on the planning merits of the case. It's not about a witness's performance. It's about the objective quality of the reasons for refusal, or by analogy in a case like this, the fundamentals of the council's position, or the reasons why it is supporting the application. The second point I'd make, if one can then turn to how that aim is achieved through the cost guidance, is if the court could turn to page 104 in the same bundle, where there is a list of the examples of the types of behaviour that might give rise to a substantive award of costs against the local planning authority. And the second of those is failure to produce evidence on appeal to substantiate each reason for refusal. And that is then reflected in other parts of the guidance, but that's the critical reference. And it is then picked up in the cases that have already been referred to, namely Chichester, North Norfolk and Wakefield. And if the court has read those, then the court will be aware that was interpreted by Mr Justice Jowett and others as meaning some substance in the sense of providing some respectable basis for their stance on a particular issue, but not of such substance as to necessarily persuade an inspector, or alternatively, I think as it was put in Wakefield, evidence not lacking in real substance, capable of belief, and which, if accepted, would be capable of making good that party's case. So what I would submit is that it doesn't follow, therefore, simply because a witness proves unable to defend or makes a concession which is fatal to a party's case of the sort that was made here, that their evidence didn't stand up to scrutiny on the merits in this sense. As this case illustrates, the fatal concession was made as a result of answers to questions on matters of planning guidance, and didn't touch on the main elements of Mr Hopwood's actual evidence or written evidence. But there are a variety of other situations which one can conceive of and which no doubt reasonably regularly occur. A witness may concede, for example, a witness may have a perfectly respectable basis for the evidence they present in written form. They may make perfectly reasonable assumptions to support the evidence that they give. But when cross-examined, it may be pointed out to them that there is a flaw in one of their assumptions. It is incorrect for one reason or another. The witness may then concede that their overall conclusion no longer holds true because of that premise has been undermined. It does not follow that that witness did not have a respectable basis, or the party in particular didn't have a respectable basis for relying on that witness at the outset. So my point is that the aim of the planning practice guidance does not indicate that you have to impose absolute liability in costs on a party for mistakes, or perhaps not even mistakes, but major concessions made by their witness.
Yeah.
The second point I make is the one that I already indicated I would in response to a question from my Lord Justice Coulson, which is that it was irrational for the decision maker, independently of the PPG, to find that the council was subject to such duty. Firstly, the point I made earlier, no party can ever ensure that their witness's evidence will withstand cross-examination. Even the best, most experienced expert may make a mistake, which wasn't something which the party calling them would necessarily have detected. One doesn't have to envisage the sort of more extreme case that my Lord Justice Coulson had in Cornish, where the witness's evidence was really well below the standard, but yet nevertheless was not held to have been something which the prosecution should have been aware of prior to cross-examination.
I may not matter to the eventual outcome of this appeal, but I wonder whether that is a question of irrationality or an error of law in imposing on a party a duty which doesn't exist.
I think the reason I put it in terms of irrationality is my learned friend would say that there are no specific rules of law confining. It is a matter of the decision maker's discretion to decide what he considers reasonable, having regard applying. I think it's accepted, and this comes from Swale, that if the decision maker purports to decide the case in accordance with the PPG guidance, he must do so or he misdirects himself. So he must be consistent with the PPG, but the PPG equally only sets out examples of types of behaviour, and so it isn't necessarily a closed list. So he would say, I suspect, that it is open to the decision maker to find unreasonableness in scenarios which aren't specifically contemplated there. But I say that that has to be within the bounds of reasonableness, and you can't impose a standard. And this court, on some matters of judgment, this court will no doubt give greater deference to a planning decision maker, albeit just a cost decision maker like Mr Parsons was, because of course he didn't hear the case. But on matters of what it is fair to expect a party to be able to do by way of expert preparation, this court is better placed, in my submission, to make a judgment on that, and therefore shouldn't refrain from saying that is outside the band of reasonable decisions or contains a process, whichever way one wishes to put it in terms of rationality. And in my submission, the correct answer, consistent with the guidance, is that the reasonable expectation and thus potentially the responsibility of the party is merely to satisfy itself that the evidence its expert is presenting meets the standards set out in North Norfolk and Wakefield. If it reasonably decides that it is, but it turns out not to be, even if it turns out not to be the case, then it hasn't acted unreasonably in the sense that the guidance is directed at. It has done what the guidance seeks it to do by relying on evidence which was capable of substantiating its case, but turned out not to be, or in cross-examination turned out not to be in the end supportive of it. But even if that is wrong, the most realistically that a party could be expected to do is form a reasonable judgment on whether it is likely that their witnesses' evidence will withstand cross-examination. And in respect of that, again, that's why I took the court earlier on to the parts of the council's submissions on costs, which made plain that the council had considered and compared the evidence of Mr. Hopwood and the HSE's witnesses and discussed the merits of both. So it had addressed its mind to that issue. And as was also said there, the HSE never explained why it could not reasonably have concluded that it was still right to stick with its original position. And again, as the court has noted, Mr. Parsons himself found that he could not conclude that the council's position was unreasonable inherently. So it was never explained why it could not do that.
Yeah, I was unable to identify from Mr. Parsons' decisions whether there was any material difference between the objections that HSE had put forward at the stage of resolution to grant and the objections it put forward in its Rule 6 statement. Mr. Parsons doesn't identify any. He may not be able to know because it's all closed, but
what I can say, because the objection was not itself closed. I don't think that was subject.
Right.
That wasn't subject to 3-2-1 direction. It was necessarily briefer, but in fact it was, the objection was based on what I took the court to right at the outset, the fact that the proposed development was in the inner consultation zone, and that indicated a certain level of risk, and that was and it was simply expanded upon. Obviously, there's much more detail in the statement of case, and then even more detail in the proofs of evidence. But yes, that is not addressed.
yeah.
And that I think it is all I wish to submit. In short, on that, it is imposing such a high standard is irrational in itself and not consistent with the PPG guidance.
Right.
Then the alternative way of looking at it, whether or not the decision maker could properly conclude that there was really no other potential explanation for the council's finding itself in the situation that it did. So if I just take the court to the relevant part of the decision, perhaps, as I've alluded to it a number of times. So it's back in the core bundle at page 189 in the HSE cost decision letter.
Well, this follows from Mr. Parsons' view that the council had a duty to ensure that Mr. Hopwood's evidence stood up to cross-examination.
Yes.
Because if they didn't, and if they had such a duty, and it was unreasonable for council not to ensure that Mr. Hopwood's evidence stood up to cross-examination, then the situation it found itself in at its inquiry was of its own making.
Yes.
So this is just a follow-up
Well-
from the way he put the first point.
Yes.
to me.
Well, if it is interpreted in that way, all I would say is, even if he had not fallen into that error, so I'm dealing on the premise that I lose that argument that he did fall into that error. Even if he did not fall into that error, the error he fell into was that he had to identify, or he had to acknowledge that there were various reasons that the cross-examination could have gone wrong in the way that it did for the council. He had to acknowledge that that was a material change in the evidence,
Yeah.
which wouldn't justify a costs award unless the council itself had done something unreasonable. And explained why he could not come to any other conclusion, including the conclusion the council invited him to come to, which is it was the result of a skillful cross-examination and dealt with matters that the council couldn't reasonably have anticipated he would address or answer in the way he did. And if I could just take the court to the authorities on that. So I do rely on Aylesbury and Cornish in that respect. If I could take the court first to Aylesbury, that is authorities tab 7, page 121.
It's not 171.
I'm sorry, I beg your pardon. So I meant 121, my lord.
121. Yeah. Yes.
So starting there, paragraph.
We have read this, so you don't need to read it all aloud. Just show us the bits you.
Well, my lord, I think the critical passage, if I may, is over the page on 122, paragraphs 23. Having noted that the expert is not indivisible from the prosecution, it's recognised there may be circumstances where the parties bears individual responsibility without being overly prescriptive. There's then reference to Cornish, and there's respectful agreement expressed with my Lord Justice Coulson's application of a test of whether it was plainly wrong in a way that should have been obvious to the Crown. What I would say in this case, that I of course have to acknowledge that there are differences between the specific test for an award of costs under Regulation 3 in the criminal cost cases regulations and in the PPG, but they don't go to the fundamental or underlying point, which is that in both cases, in order for the party calling the expert to be found responsible and liable in costs, it must be at fault. The characterisation or the level of the fault may be different in each case, but fault is necessary in both cases. And I say that must be the case because, again, if it were not the case, it would be antithetical to the fundamental rule which I took the court to in PPG paragraph 30, that costs are only awarded for the unreasonable behaviour of a party. And as my Lord says, that is the only power that the Secretary of State has in section 250.
Yeah.
And I say in particular, even if Mr. Parsons didn't fall into the error of applying an irrationally high standard, even if he didn't do that, he failed to consider the potential alternative explanations. So he didn't address any. He had the evidence of Mr. Hopwood. He had the submissions of the parties. He could have looked at them and seen whether there was anything there that should have been obvious to the council, made it obvious that Mr. Hopwood was going to make the sort of concessions that he make. He didn't do that.
That's the point that Lady Justice Sharp is making in paragraph 24.
Yes.
About halfway through, she says, Mr. Teverton Jones points out an expert has an expertise which the prosecuting authorities don't have, hence the need to instruct him. once the expert in this case has given his opinion the image was accessible, there was nothing to suggest a need to interrogate the expert.
Yes, and as I say, notwithstanding the differences in the test, the same principle must apply. Maybe the degree of fault is a bit lower, but there has to be some fault. There has to be some fault. We didn't do something in relation to Mr. Hopwood's evidence that we ought to have done. And this is, he doesn't consider, let alone answer that question in DL20 or any other part of the two decisions. My Lord, I think those are, again, I'm conscious, I had intended to go to, originally intended to go to Cornish. I'm very conscious now I know the constitution of the court. That may be less necessary, at least for some of the court. I'm happy to take the court through that if you wish, but I'm also aware, my Lord, you said you've read it. So I do not want to harp on things that are already clear in the mind of the court. So I think those are my essential submissions on both parts of ground one. Ground two I can take even more briefly because it is simply an alternative argument that if notwithstanding what is said, the court concludes that it wasn't irrational for Mr. Parsons to conclude that the council was responsible, he still failed to explain to the council what it had done wrong or why it was considered that the only explanation for what had happened was that it must have done something wrong.
Yeah.
And so it doesn't meet the standard in South Bucks and Porter.
Right. Thank you, Mr.
Thank you, Madam.
Yes, Mr. Williams.
I'm grateful, my Lord. My Lord, as is common ground, the decision maker in the costs case in planning has a wide statutory power. The policy now contained in the PPG, but is long-standing, guides the exercise of that discretionary power. My learned friends, taking you to the central test, policy test, whether the party has behaved unreasonably, and if so, whether that unreasonable behaviour has caused any other party to incur unnecessary costs. The decision maker in this case, Mr. Parsons, concluded the council had acted unreasonably. That was a matter of evaluative judgment for him, which the High Court and this court could only interfere if he'd exercised that judgment unlawfully, and in particular, in the way that it's been put, if he'd exercised it irrationally, that is, if there was a demonstrable flaw in his reasoning. And in essence, he concluded that by calling an expert witness on public safety matters, whose evidence didn't stand up to scrutiny, not in the sense that it was knocked down slightly or that the inspector didn't ultimately agree with the expert witness or the other witness that was referred, but that it didn't stand up to scrutiny in the sense that the council, in light of that evidence, had to withdraw its case.
Yeah.
The decision maker concluded that amounted to unreasonable behaviour. And as I say, the central and really sole issue for this court, on ground one at least, is whether that was a conclusion open to the decision maker or whether there's a demonstrable flaw in his reasoning. Now, my lord and my lady, I'm going to just make some overarching points before turning to, very briefly, the law decision letter, Mr. Justice Fordham's judgment. I appreciate my lord and lady will have read it. I'll take it briefly,
yes,
and then turn to my submissions.
Indeed, and bear in mind that that what we are concentrating on is not so much Mr. Justice Fordham's judgment, but Mr. Parsons' decision.
Entirely agree, my lord, but Mr. Justice Fordham, in my respectful submission, came to the right conclusion, I would say that, wouldn't I? But actually his reasons for doing so I would wish to ally with pray and aid on a number of matters, and that's what I'll take you to. But I won't detain the court for too long in relation. If I could use my skeleton argument, page 2, paragraphs 4 to 9, where I start with the overarching points, and I could take these briefly. This is beginning with paragraph 4. Whether the council had acted reasonably for the purposes of the PPG, that is in the non-Wednesbury sense, the conventional meaning of reasonably, was a matter of evaluative judgment, and a point I've already made this court and the court below exercising only a supervisory jurisdiction. Second point is that the decision maker exercises a wide statutory power. I simply rely on the case law that Ms Justice Fordham refers to there. I provide the paragraph. There's no dispute between us on that. I'm not going to detain the court any further on that. Third point I do need to say something about. Ms Justice Fordham recognised that Mr Parsons was in a better position than him, even though he wasn't the inspector in the case, to make a judgment on unreasonableness, quite apart from the supervisory nature of his function. And that's because the cost decision maker, who was subject to the 321 direction, had evidence before him that Mr Justice Fordham didn't and that this court doesn't. That includes statement of case, proofs of evidence, and an unagreed note of the cross-examination of Mr Hopwood's evidence. Now, I don't want to push that point too far, my lord, but some of the submissions made by my learned friend today did enter into the realm of what was said and what was in the closed session and what was the basis for Mr Hopwood's concession, and whether it, in effect, went to the heart of Mr Hopwood's case on public safety matters, or whether it was a clever cross-examination on the basis of a PPG. I put that flippantly, and I don't mean it flippantly, but I just urge the court to be wary of making findings or basing its decision on the basis of evidence which is not before this court, but was before Mr Parsons. And it's an additional reason why this, in my submission, this court should tread carefully before it decides to interfere with Mr Parsons. The fourth point I would like to underscore, if I may. I do say, and we do say on behalf of the Secretary of State, this is wholly unremarkable that costs were awarded against the council in this case. And just to elucidate or build upon that, although not the applicant at the inquiry, the council were the main proponent of the application. They had resolved to grant permission for the scheme. That resolution was in the teeth of long-standing objection from the HSC, who raised serious concerns on grounds of health, of public safety, because of the proximity of the site to chemical works. It was because of that dispute between the HSC and the council, and on that particular issue, public safety issue, that the application was called in and the inquiry was heard. The council's case was that the scheme could be safely developed, and they called evidence to substantiate that position. That evidence was primarily in the form of Mr Hopwood's evidence to that effect. That was the central issue at the inquiry. That evidence collapsed under cross-examination to the extent that the public safety witness agreed that were he in the inspector's shoes, he would not recommend granting permission. In fact, he would recommend refusing permission. And in light of that evidence, the council withdrew their support for the scheme, and an inquiry that was listed for 7 days and had multiple parties collapse.
The submissions to Mr Parsons, in effect, I think both sides said that Mr Hopwood's evidence changed because of something in the NPPF.
My lords, that goes back to my previous point. In my submission, it's inapposite to speculate about that. I wasn't privy to.
Well, I think that's both what Mr Kimblin said in his submissions on behalf of HSE and what the council said. So that seems to have been the agreed position before Mr Parsons.
Because, sorry, my lord, because of a change in the NPPF.
No, there wasn't a change in the
No.
NPPF as I understood it. It was that Mr. Kimblin, as he then was, put something in the NPPF to Mr. Hopkins, which undermined his evidence.
I thought it was the PPG, but it may or may not be. But that may well be right, my lord. I don't
Do we know what it was?
If I can assist, I think the relevant paragraph is paragraph 19, page 8 of the supplementary bundle. It's the PPG that is referred to.
Paragraph, page 19, sorry, page 19.
Page 8, paragraph 19.
And this is Mr. Kimblin's document.
It is. It is.
Yeah. The local policy failed to follow the principles in the MPPG. When the MPPG principles are followed, the outcome is to advise against. What is it? What do we know what he was actually referring to?
My lord, I don't know, because I haven't seen him privy to the cross-examination notes, and I wasn't obviously there. My little friend was there, but whatever it was, what we do know is that the evidence of Mr. Hopwood was that planning permission should be refused, and the effect of that, the council withdrew the support for the scheme, and that a 7-day inquiry collapsed. Now, of course, I say that it might be thought that that's a paradigmatic case where costs ought to be awarded in a case. My lords and ladies will know that in the vast majority of planning inquiries, I put aside enforcement notices and certificates of lawfulness, but in the vast majority of planning cases involving planning merits, evidence is given by expert witness. Highways, landscape, noise, viability, planning, all expert witnesses. So where your expert witness collapses, and with it your case on a particular point that you have based your case, one would think it's a paradigmatic case where costs may be awarded. Now, my lords and ladies, I don't need to persuade you that this is an appropriate case for an award to be made. All I need to persuade you is that Mr. Parsons' decision to make the award in this case was not unlawful. The fifth point in my skeleton argument, which I turn over the page on page 3, is it was argued below that Mr. Parsons had misdirected himself as to the test to be applied and misinterpreted the PPG. Mr. Justice Fordham dismissed that ground of challenge, and that ground of challenge has not been renewed. So this court must properly proceed on the basis that Mr. Parsons properly understood and interpreted the guidance in the PPG. The sixth point that I wish to emphasise is that Mr. Parsons' award in my submission is entirely consistent with the PPG's guidance on when costs awards will be appropriate, particularly in called-in decisions. I'll take my lords and ladies to the decision letter momentarily, but he quite clear applied paragraph 34 of the PPG, which deals expressly with called-in decisions, and he applied the final line of that, which indicates that parties may be at risk of costs when they've aborted the process by withdrawing the application without good reason. And the question for Mr. Hopwood, the one that he posed himself and answered, was there good reason for the withdrawal? Mr. Parsons, I'm sorry.
But everybody agreed there was a good reason.
My lord, there was a good reason for doing it at that stage, and this is a...
The words are very clear, including aborting the process by withdrawing the application without good reason.
Absolutely.
There's no temporal element to that beyond withdrawal.
Well, with respect, my lord, I submit that there is a temporal element that Mr. Justice Fordham identified.
Well, that's going to be part of the issue.
Yes.
But on plain words, everybody agreed it was withdrawn for good reason, because the expert had said, well, if I were you, I wouldn't allow this application.
And so the decision then to withdraw and not to increase the costs by further sitting days was of good reason. The question about whether there should have been an earlier withdrawal, or whether that evidence should ever have been put forward.
Well, we'll need to. That's what we need to look at. We need to look at the decision maker's letter on that point.
Yes. And the decision, and I'll come to in a moment what I say the essence of the reasoning of the decision maker is. But in short, I say that he found that there was not good reason in this case for the late withdrawal, because that evidence, they put forward evidence that wasn't capable of standing up to scrutiny and weren't able to prosecute the decision, their case to a decision.
Well, you're going to have to explain how that stacks up. What Mr. Kimlin was submitting to Mr. Parsons, as we've just seen in paragraph 19, was that the council's policy did not comply with the NPPG. The council refused or resolved to grant permission based on its development plan and policy. And that was not unreasonable, so says Mr. Parsons, rejecting the argument put forward both by HSE and Viridor that the objections by HSE were overwhelming and it was unreasonable to resolve to grant in the first place. Well,
Mr. Parsons is not in a position to be able to come to that judgment because there's no ultimate decision made.
Now, the judge thought that was only because it was pre-call-in behaviour, but speaking for myself, I think that Mr. Parsons rejected that argument on its merits, not just because it was pre-call-in behaviour. So the question then is, well, what is it that the council should have done after the resolution to grant to reappraise its policy? Is that what's being suggested? Because that was the ground, that seems to be the ground on which Mr. Hopwood's evidence collapsed. Or is there some other, quote, normal procedural requirement, to use Mr. Parsons' phrase, which the council didn't comply with? And I would like to know what that normal procedural requirement is. It's not suggested that there was a failure to comply with Rule 6. It's not suggested there was a failure to comply with Rule 13. Not suggested that at the pre-inquiry meeting, the inspector directed something, like a meeting of experts, with which the council didn't comply. So where is the procedural requirement, a normal procedural requirement, with which the council did not comply?
In my submission, my lord, the requirement, that Mr. Parsons concluded that there was an onus on the council to call evidence in support of his case that was capable of standing up to scrutiny, in the sense it wouldn't fully collapse, and therefore prosecute their case to a decision. And that was the requirement to which he was referring. He wasn't referring to a specific rule in the inquiry procedure.
No.
He wasn't saying that the evidence had been put in late, or that they hadn't agreed a statement of common ground. That wasn't the failing identified in this case. The failing identified in this case was that the council failed to substantiate the central bases on which they had a dispute with the HSE, namely whether there were public safety concerns in respect to development of this site. Because those policies, my lord, obviously, and we're speculating here, but they're not applied in a vacuum. They are and will have been concerned with whether development can safely come forwards, notwithstanding the presence of the chemical works.
Well, on that basis, I would have expected Mr. Parsons to say that this application for planning permission was bound to fail. But he doesn't. He says, well, who knows what would have happened?
He does that because the decision maker doesn't come to a final judgment in relation to it. It may well have been open to him, my lord, I have to say, to come to, and reasonable within the bounds of Wednesbury reasonableness, to come to the conclusion that the mere fact that now all of the expert evidence was against the proposition that this was a safe development meant that it was never appropriate to have advanced that proposition and that and to have awarded costs on substantive grounds. He doesn't do that.
No.
So it would have been within the, it may have been within the bounds of reasonableness to do that. I'm not defending that decision. He comes to the separate judgment that having advanced a case on public safety grounds, advanced the case that there were no public safety grounds to refuse this development and supporting it. The council weren't able to make good that proposition, not in the sense that the inspector preferred the evidence to the HSC, but they weren't able to make good that proposition by prosecuting it to a decision itself. Just to bring me back to my final overarching submission, I do say that it was open and not irrational for Mr. Parsons to conclude that there was an onus on the council to ensure that they called evidence to support their case, which stood up to scrutiny in the sense that it didn't completely collapse. And that is consistent with the guidance in the PPG. My learned friend quite properly took you to those paragraphs, and if I can, in the PPG with which it is consistent. My Lords and Ladies, if I could turn your attention first of all to supplementary bundle, page 91. The aims of the cost regime is stated there. And I pause here to say that it is very important to note that the aims of the cost regime in planning are fundamentally different to the aims of the cost regime under Section 19 of the Prosecution of Offenders Act 1985. The aims under there, which we'll come to, of the cost regime, are to dissuade improper action. And the courts have made it clear, including my Lord, Lord Coulson in the Cornish case, that Section 19 application shouldn't be used in order to dissuade prosecution decision makers to make difficult decisions on what and what not to prosecute. The aims and the costs of the cost regime planning are very different, and they include bullet 1, as well as pure procedural matters such as follow good practice, both in terms of timeliness, but in presentation of full and detailed evidence to support their case. And then go on to say, particularly in relation to local planning authorities, to rely only on reasons for refusal which stand up to the scrutiny on the planning merits of the case. Now, my lords and my ladies, by comparative reason, that must also mean to rely on reasons in support of cases which only stand up to scrutiny on the planning merits of the case. And my learned friend in his submission sought to draw a distinction between, temporal distinction, between the situation when they were reviewing the evidence and the situation after cross-examination, and to say that it was only after cross-examination that it became apparent to them. But my lords and ladies, the aim of the cost regime, in short, is to ensure that you do put forward a respectable basis for your case. If you don't do so, you're at risk of costs. Now, if you call an expert witness on a topic that completely collapses on that issue on which you have advanced, if it's a reason for refusal, let's say it's a highways reason for refusal, and you refuse to grant planning permission for a scheme because you say it's unsafe access, the appellants appeal and they call an expert witness that shows it's safe, and in cross-examination your witness collapses on that point, and you withdraw, perhaps it's only one of the reasons for refusal, you withdraw your reason for refusal on access, the type of thing that happens day in, day out in planning inquiries. That reason for refusal hasn't stood up to scrutiny on the planning merits of the case.
But standing up to scrutiny on the planning merits of the case, the loser's evidence will always not have stood up to scrutiny.
Absolutely.
And the regime is not that the loser always pays.
Absolutely, my lord. So that's when we look at the cases, and we can come to them, as to what does stand up to scrutiny mean. And my lord, I can come to those shortly, but they mean to put forward a respectful basis for your case, and if you've had,
Yeah.
if you put forward evidence which collapses under cross-examination, it's at least open to a cost decision maker to say you haven't put forward a respectful basis for your conclusion. In
So
fact,
when was it here that the council's case moved from respectable, because it's not unreasonable to resolve to grant, to becoming not respectable?
well, in my submission, my lord, when they decided to call Mr.
How
Hopwood,
does the decision maker say when that movement happened?
he doesn't in terms, my lord.
But isn't that critical if this is his reasoning that actually his elliptical words mean they should have withdrawn it earlier?
My lord, in my respectful submission, he is saying that at some point they ought to have put the points, and this is put the points that Mr. Kim put Mr. Hopwood. And had they done that, had they listed the answers, they wouldn't have advanced and shouldn't have advanced him as a witness in support of their case. And indeed, they shouldn't have advanced that case because they knew their case wouldn't stand up to scrutiny. Not in the sense that...
So, just a minute. So, what they should have done is anticipated the questions that Mr. Kimblin was going to ask in cross-examination.
I say that it was open to Mr. Parsons to conclude that there was an onus on them to call expert evidence which stands up to scrutiny, and part in unpacking that.
But my lord has just asked you when did the council's case on public safety move from being, I think your word was respectable, which it would have been given Mr. Parsons' conclusion on the resolution to grant, to being so feeble that the council in some way were at fault? And your answer, as I understood it, was that the council should have put to Mr. Hopwood the questions that Mr. Kimblin put to him in the course of the cross-examination in the closed session. So the logic behind that is that the council should have anticipated the questions that Mr. Kimblin was going to ask Mr. Hopwood. Otherwise, how could they have put those questions? That's your submission.
That's part of my submission. What I would say was I don't agree with the premise that they moved from a respectful basis to a not respectful basis for their position.
But if the council's case on public safety had never been respectable, then surely Mr. Parsons would have accepted the argument put by Viridor, amongst others, that the objections on public safety were overwhelming, such that the council should never have resolved to grant permission in the first place.
With my lord, as I say, he could have come to that conclusion. He didn't come to the conclusion that he was going to make it because he said that there had not been a judgment reached by the inspector on the matters of public safety. There hadn't been a judgment reached by the inspector on the matter of safety because the council had withdrawn its position that
then how are you able to say that the council's case on public safety was never respectable? When that goes against what Mr. Parsons actually said.
I don't go that far. I don't go as far as to say it was never. I say that there's no positive case that it was. There's no finding that it was ever respectful. We simply don't know because there was never a judgment reached by this inspector as to whether it was or not.
Right.
But my lord, coming back to the PPG, and looking at the aims of the PPG in a planning context where evidence invariably is given in these types of cases by experts, as I say, it is entirely consistent with the aims of the PPG to impose, and certainly not irrational, and that's all I persuade this court, to impose an onus on the council that their expert evidence stood up to scrutiny and that they were able to prosecute their case through to a decision. And My Lord, those are my overarching submissions. On law, I want to address the court briefly on two matters. One
Before
is
you do that, could you just clarify for me again what you really mean by stood up to scrutiny?
What I really-
You said stood up to scrutiny and prosecute to an outcome.
Yes.
Stood up to scrutiny?
In this, what I mean by stood up to scrutiny, my lady, is that it certainly isn't of a standard that it collapses under cross-examination. It provides a respectful basis for maintaining, in a reasoned refusal, your objection to a scheme, even if it's not going to persuade an inspector.
So you make the difference between your witness is cross-examined and in the end the inspector or whoever it is prefers the other side's evidence.
Absolutely.
That's one thing. And your witness is cross-examined and has to admit that it doesn't work.
Exactly. And has to admit it doesn't work, and then, in this case, goes as far as to say that permission should be refused. Or if you were defending a reasoned refusal, that this wasn't a proper basis on which to refuse permission.
And so the duty, you would say, just so that I'm absolutely clear, so I don't want to repeat matters, the duty you would say upon on a council is to anticipate all reasonable questions that can be put to an expert?
Not all reasonable, not every single question that may be put, or all reasonable questions that would be put, but to the line of questioning that may expose a fundamental flaw in their evidence. I mean, in this case, this is not a case in which the expert's evidence was knocked down and he agreed that part of his evidence was flawed, but he still had some arguments. This was a fundamental issue whereby the questioning led to the conclusion that he would recommend refusing grant permission. And it was open, in my respectful submission, for the cost decision maker to conclude that there was an onus on the council to ensure that the evidence stood up to scrutiny in the sense that it did not collapse to that extent.
Okay. Sorry, I interrupted you.
My lords, I was going to deal with the law, just two matters. One is the principles to be derived from the case law, which I accept is all at the High Court level, but involve propositions which I don't think are in dispute on cost decisions in planning cases. And the second is that the approach that this court should take when reviewing the rationality of Mr. Parsons' decisions. I can take both pretty briefly because I think they're uncontroversial.
Right.
The first, I can take very briefly. Those are, I can do no better than referring this court to the judgment of Mr. Justice Fordham, core bundle, paragraph 16, page 27, paragraph 16. In those paragraphs, Mr. Justice Fordham runs through 5 of the cases, 4 of which this court has in the authorities bundle, and then from those cases derives a number of propositions at 17, little Roman numeral 1 to little Roman numeral 4. Just ask the court read that very briefly.
I don't understand Mr. Hunter to challenge.
To challenge any of those. The second matter is just picking up on that. In paragraph 18.2, Mr. Justice Fordham referred to the two aspects of public law and reasonableness. There has been further learning on that, and I'd just like to take the court very briefly to that learning in order to...
So it's the difference between process irrationality...
Process and rationality and outcome, but also the standard of rationality. And I will be brief because I don't think there's much dispute, but it is the prism which I respectfully say this court must apply or see this case and apply that rationality standard. And as you hear, we both agree that this is a rationality case, whether it's process or outcome. And that is the Winchmore School case, that's tab 9 of the authorities bundle. And within that, page 176 of the bundle, paragraph 44 of the judgment. This was within the judgment of Lord Justice Edis, where he approved Mr. Justice Chamberlain's analysis in the KP case.
He was in the minority, but I don't suppose the other two judges
disagreed with his analysis of the difference between process and
but did Lady Justice Lang and Lord Justice Arnold agree on the difference?
My Lord, whilst one's reading that, I don't know whether they positively agreed. I will look that up.
But anyway, you've got what Mr. Justice Chamberlain said.
Yes. So we have what Mr. Justice Chamberlain said in terms of the different aspects of rationality. Mm-hmm. And as I understood the case, put by my learned friend, we were in the ambit of process rationality. In essence, he was saying that there's a demonstrable flaw in the reasoning of the decision maker. But then there's also the issue of the standard of review that should apply, and that is dealt with by Lord Justice, again citing from Mr. Justice Chamberlain in KP, paragraphs 45 to 47. My Lords, you may well have read that. But in short, the proposition is that the standard of review is a flexible standard, depending on the circumstances of the case and the gravity of the potential consequences. And where a heightened or anxious scrutiny is appropriate, the court will subject the decision to a more rigorous examination just to ensure it's in no way flawed. But then if we turn on to page 188 and paragraph 65, Lord Justice Edis gives some guidance as to the significance of the standard of review. It affects the way in which the court will defer to the expert judgment of the decision maker to whom Parliament by statute has entrusted decisions. It affects the benevolence with which the court will read the reasons given in the decision letter. And I should say that Mr. Justice Chamberlain in KP, for what it's worth, emphasised in that case that the standard of review has implications for both process and outcome irrationality. And in my submission, it plainly does, and that's consistent with what Lord Justice Edis says there about the benevolence with which the court will read the reasons in the decision letter. That plainly applies to process rationality. Now,
here I'm not at all sure that the other two judges did agree with him. We've got Lady Justice Elizabeth Lang at page 210, paragraph 122 and following. And I must say, I have not read this closely closely enough to see what, if any, disagreements there were on this reasoning, although they did disagree on the outcome. And then Lord Justice Arnold agrees with Lady Justice Lang. And he deals with ground 3 at para 134.
As I understand it, my Lord, there may have been disagreement about the ultimate outcome and also about the standard of scrutiny to apply in that case, but not about the principle, one, outcome and process rationality, and two, the standard of review is a flexible one and and that flexibility can apply to both limbs of rationality. That's my simple proposition in this case. And then I go on to say...
Where are we on that sliding scale?
Well, that's exactly my Lord has foreshadowed what I was about to say. I say this is not a case, and not an appropriate case for any heightened standard of review, and I say that for 3 reasons. One, it concerns the wasted costs of an inquiry, which no doubt important to the parties, and particularly the council, cannot be equated with cases which involve convention rights or exclusion from education, or deprivation of liberty, or the like.
And may depend on your view of costs. Some of us regard costs as really very important.
They are.
Some of us regard convention claims very often as bordering on the rubbish heap.
That depends on the
Exactly.
particular.
So I'm not sure that sweeping generalisation, just because this is to do with costs, is a fair factor to take into account.
Well, with my lord, I respectfully.
This is. We're in the Court of Appeal. This is about costs. Costs between a government department and a local authority. I mean, people must regard it as important.
My lord, I don't mean anything I say to say this is not an important case for the Court of Appeal to determine, wouldn't have granted permission if it didn't think it was, or for the parties involved. What I do say is that the issues involved do not give rise to matters which conventionally have prompted a heightened standard of review.
Right.
Secondly, the wasted costs of the inquiry have to fall somewhere. If this decision, if the appeal is upheld and the costs are not borne by the local authority, they're borne by the HSC and Burial. Thirdly, obviously those wasted costs are subject to taxation and the only recoverable costs are assessment. My lord, and are only recoverable to the extent that they are reasonable. And therefore, I don't understand it's argued against me, or I'll hear what's in reply. There's no proper basis here to apply an especially high standard of scrutiny, and the standard approach in terms of rationality ought to be applied in my respect.
Is the nature of the decision of any significance? I mean, if, for instance, the decision were a planning judgment about the value of a heritage asset, this court would say, well, we can't decide that kind of thing. That's obviously for the primary decision maker. But this decision is about what are parties' duties in the conduct of what, to all intents and purposes, is litigation. Now, I know it's called an inquiry and the decision maker is the Secretary of State and the inspector is going to report and all that, but in effect, this is a contest. It's fought out not in court, but in...
It's an adversarial process.
It's an adversarial
Absolutely.
process between HSE on the one side, council on the other. It's about parties' duties relating to expert witnesses. Isn't this court able to decide those questions without undue deference to the decision maker, whereas some planning decisions the court couldn't possibly make?
My lord, I haven't emphasised that for that very reason. I don't say that the issues in play, the court doesn't have the expertise in which to opine in a way that you'd pay greater deference in relation to matters of pure planning judgment per se. But I do say that there are no particular factors here which suggest a heightened scrutiny because of the consequences of the decision. I hope that's clear. My lord, I was going to go to the decision letter. My lords and ladies have read it in detail.
Yes.
My lord, you did raise a question, and this is why I wanted to go to about the apparent contradiction between no change in circumstance.
Yes, between paragraphs 17 and 20.
Yeah, I thought I'd best deal with that. But if I'm going to do that, I would like to put this into context. So, come to the decision. We're looking here at the HSE decision letter, which begins at 185.
Yes.
And I can briefly go through it, but if we look at page 186, there's a heading, basis for dealing with the cost applications. And you can see that Mr. Parsons sets out the relevant sections of the PPG, fully understands that as paragraph 5, that parties normally bear their own costs, sets out the test for those costs, recognises that the position is different in called inquiries, that's paragraph 6,
Yeah.
cites the relevant guidance applicable to called in inquiries, that's paragraph 34 of the PPG.
Yes.
And then reasons for the decision. He says the main decisive issue is paragraph 10, second sentence. Main decisive issue in this case is whether or not Halton Borough Council acted unreasonably in the called-in proceedings. We actually have a bit more elucidation about what he means if we go to the Viridor letter. This is page 192. The main decisive issue in this case is whether or not Halton Borough Council acted unreasonably by withdrawing their support for the planning application at a late stage in the called-in proceedings. And so we can see there that's a sort of a more specific formulation of the central issue.
Yeah.
We get his reasons beginning at if we go back into the HSE at 188, we know that the substance of the reasons are in the HSE decision letter. And my lord's already picked up on the point that at paragraph 15, where he addressed the HSE's application for a full award on a substantive basis and rejected that, but at paragraph 16 applied the final sentence of paragraph 34. Was there a good reason for aborting the proceedings or withdrawing their support for the application, which had the effect of aborting the proceedings? And he gives his reasons from para 16 through to para 20 for concluding there was no such good reasons.
What is the normal procedural requirement that he is referring to in the first sentence of paragraph 16?
That, my lord, if we pick up the para 34 of the PPG, is a citation from paragraph 34 of the PPG. So it's page 94 of the supplementary bundle. He says the PPG makes clear that parties failure to comply with normal procedural requirements for inquiries may place them at risk of partial award of costs, and that is, if not a direct citation, in substance what is said by the final sentence in paragraph 34 at page 94. However, parties fail to comply with the normal procedural requirements of inquiries, including aborting the process by withdrawing the application without good reason. And it's that procedural requirement that he was talking
But everybody agrees that there was a good reason for withdrawal.
My lord, sorry.
Everybody agrees there was a good reason for withdrawal in the light of Mr. Hopwood's evidence.
At that time, absolutely.
Right, so there must be some other normal procedural requirement that Mr. Parsons is referring to in order to support the conclusion that the support for the application should have been withdrawn earlier.
With respect, my lord, no, because there was a good reason. This is a temporal point that Mr. Justice Fordham deals with.
Yeah.
There was good reason for withdrawing the support for the application then. In fact, it would be thoroughly unreasonable behaviour to continue on and prosecute to the conclusion if you had no evidence whatsoever.
Yeah.
But that doesn't mean that there was a good reason for having called that evidence and caused the inquiry to occur in the first place. That is the absence of good reason in this case. My lord, it's very neatly put in my respectful position by Mr. Justice Fordham.
Well, let's stick to the decision letter. Where does he say that?
He doesn't in terms.
And the trouble is, at 18, he says the council hasn't explained the details of the responses given by Mr. Hopwood that caused them to change their position.
Yes.
Well, we all know what that was. It was because he said if he was the inspector, he wouldn't allow the application. So what is it that was not clear to the decision maker in the first sentence of paragraph 18?
I speculate here, but obviously that's a matter for him to have concluded upon. But if they had said, for instance, the line of questioning that Mr. Kimblin put to the witness, in response, we have put and got different answers, that may have been, if they had had a detailed breakdown of what those questions were, indicate that we'd asked the same questions or the same theme, that may have provided the decision maker with the clarity he was looking for.
So there's some sort of duty, is there, to waive legal professional privilege or litigation privilege?
Not duty to waive it, but they could have. They could have.
Well, you have to put it as hard as a duty because the case against the council is they were acting unreasonably.
Absolutely unreasonable.
And it's not normally unreasonable, is it, to rely on legal professional privilege?
It's not my or normally unreasonable. I accept that, but it would be it could have been a justifying factor if they had said in their response, these themes were put to Mr. Hopwood by Mr. Kimberlin. We had anticipated that, and we'd asked those questions, and he'd answered it very differently when we'd done that.
Yeah.
And that they could have chosen to do that, and were entitled to do that.
Yeah. Or perhaps they might have said, well, we never expected that question. Those questions just came out of the blue.
Well, that then may well have been unreasonable in circumstances where the result of those questions is the complete collapse of their case on the public safety issues. I mean, this is not a side issue. This is the sole issue why we're having this inquiry.
Right.
And so, again, it's difficult because we don't have the transcript of what was asked. The decision maker has an unagreed note, we don't. But we can infer quite properly that the questions that were asked went to the heart of the evidence and fundamentally undermined them. Because if, frankly, Mr. Hunter is experienced enough to say, well, yes, he may have knocked him down on some points, but they're totally irrelevant to the actual substance of the public safety issue in question. If that really were the conclusion, the council could have progressed on with their witness and prosecuted it to a conclusion. This must have been a fundamental volte-face on the substance of the Mr. Hopwood's evidence.
Your answer to my earlier question, you said, well, there was a good reason to do it then, i.e. when they did it, but that doesn't mean that there was a good reason to cause the inquiry to occur in the first place. And that goes back to my Lord's point, that if that were right, one would have expected to see the reason being this was doomed from the start.
But, my Lord, the decision maker, it was within the decision maker's ambit of judgment to say, I can't come to a conclusion on the substance.
So it wasn't doomed from the start. That's not a reason that he gives. So your answer to my point, it goes beyond what the decision maker did.
No, my Lord, he isn't able to come to a positive judgment that it was doomed from the start.
No.
Okay.
And therefore the difficulty with all of this, because that's what effectively the council was unreasonable, you say, for allowing this whole thing to happen, trying to causing it to occur in the first place.
I say it was open to Mr. Parsons and not irrational to come to that conclusion.
And yet the decision maker doesn't deal with that at all, save to say that he can't come to a view. Because
the inspector didn't come to a conclusion on that matter. But what the decision maker did know is that the council caused this inquiry to occur by supporting the case for the development in the teeth of the objection by the HSE. Because of its position that it was safe to develop it. It did not and was unable to prosecute that case to a conclusion. It in my respectful submission, was open to Mr. Parsons to find that that was unreasonable. The failure to be able to do that, he didn't then need to come to a separate judgment as to the substance of the issue. The mere failure of being able to prosecute your position to a conclusion was a factor which Mr. Parsons could have concluded reasonably was unreasonable in the sense of the cost guidance.
But if that were right, that would be a perverse incentive for people who get into difficulties in inquiries not to take them through to a conclusion, come what may.
With respect, no, my lord, because in that circumstance, although the cost guidance says you're not normally at risk of costs on a substantive ground in called inquiries, if you've pushed on, notwithstanding the collapse of your sole witness on the central basis on which you're advancing this case, that's an additional form of unreasonableness that's going to give rise to additional costs. What you're doing by withdrawing your case there is mitigating that unreasonable, mitigating the costs.
Well, I get
so it doesn't. I don't accept the perverse incentive.
I get that, but we're here because of the rule, which you say is what he meant by the normal procedural requirement in relation to withdrawal without good reason.
Yeah, we absolutely are, and it was for the decision maker's judgment as to whether there was or not good reason in this case.
And he has added when they did.
When he has, it's quite absolutely he's quite clear that he's added when they did. He added it to the. He added the late withdrawal to the issue in the Viridor case, and he added when they did to paragraph 16 and also paragraph 20.
Yeah.
But my lord, going back to it, it's not said against me that he's misunderstood the guidance. And it was said against me below, this wasn't a point that was taken below, even in that context. So this court, in my respect, had to proceed on the basis that this cost decision maker did properly understand and did not misinterpret that guidance.
And we're saying here that the duty of a party is to make sure that their expert evidence isn't fundamentally flawed. Is that how you would put it?
Yes, and one evidence of it being fundamentally flawed is if it collapses under cross-examination entirely. And in fact, it may be too far to say fundamentally flawed. The case law talks about putting a respectful basis forward for the evidence, and that would be the threshold. My lord took the court earlier to the passage in Mr. Justice Jarrett's case about that issue. And that's the standard, that if you are able to produce evidence that and maintain that evidence that goes beyond a respectful basis, then even if you ultimately lose, you're unlikely to be at risk of a award of cost, although Mr. Justice Jarrett says there may be other reasons why you have an award of costs. But in this case, the council didn't get to that evidential standard. Something we're jumping around, but it's it's entirely my fault, but it was something else.
I think it's mine.
Oh, my lord. Not at all. I hope I'm answering the questions.
You are.
But my lord, what I haven't answered is your concern, my lord, about the apparent inconsistency between the conclusion that that there had been a change in the evidence of Mr. Hopwood, but in paragraph 17, but that nothing had changed in paragraph 20.
Yeah.
And the short point in respect of that is that read fairly as a whole, what Mr. Parsons must be saying in paragraph 20, when he says, second sentence, instead the council changed their previous stance on the inquiry, but it's evident there had been no material change in the planning circumstances or evidence sufficient to justify such a vote class. Well, he's obviously considering there, in the change of planning circumstances, i.e. there'd been no change of policy, which may have justified a change in Mr. Hopwood's evidence. And in terms of new evidence, for instance, the HSC hadn't, or Viridor, or the operator of the chemical works hadn't produced new evidence to show one way or the other that it's safer or less safe to develop in this way.
Is this some sort of an objective test? I ask that question because in paragraph 20, Mr. Parsons is saying there's no material change in the planning circumstances or evidence sufficient to justify a volte-face. And in paragraph 26 of the Viridor letter, he says the council's change in stance with regard to withdrawing their support is a material change in the planning circumstances. And therefore Gleeson's were not unreasonable in withdrawing the application. Now, how do we put those two together?
That must flow from his judgment that there was an onus on the council to call evidence that stood up to scrutiny.
Yeah.
Because there's no change from the perspective of the council in the sense that they were always under that duty. There was no extraneous factor that gave rise to the justification for their change of stance. Whereas in Gleeson, there was, because they were not the party supporting the case on the public safety grounds.
Right, so we're back to the question of duty to ensure the evidence stands up to scrutiny.
Scrutiny in the sense that it's not fundamentally flawed or is a respectful basis, yes.
Yeah, and how is that done in practice? I mean, obviously you read the expert's report, which is submitted to the person who's going to call the expert. There's nothing obviously wrong with it. What do you do then?
Practically, how do you
what are you supposed to do?
You're entitled, and Mr. Parsons concluded that they ought to have, he doesn't go this far, but to have tested that evidence, perfectly proper, and happens in planning inquiries regularly, that one, including in this case, because we know that there were meetings between council and Mr. Hotwood, perfectly proper to test the evidence of the expert before you decide to rely upon it, before you put the proof of evidence, because my lords and ladies will know there aren't expert reports per se in planning inquiries to the experts, because they are, as I say, almost ubiquitous in planning inquiries determining the merits. They're dealt with in proofs of evidence, and before one does that, before council is involved, often in this, other are also clients in an appropriate way testing that evidence. Not by coaching, that would go well beyond what is permitted under the bar council rules and also under the professional obligations, but by properly testing that evidence to see what the strengths and weaknesses are before it's submitted. And then when one receives the other side's evidence, you do the same thing. Are the points that they're making knockout points here, such that we really do need to withdraw our case? That happens day in, day out in planning inquiries, and it is not unusual. I wouldn't say it's frequent, but it's not unusual for expert evidence to either be withdrawn at some stage. That, and as I started with, that is a paradigmatic example of when costs are rewarded in a planning case. Because let's say the local authority has maintained an objection on access grounds and has produced evidence to say it's unsafe, then receives the other side's evidence and said, oh, we've got it wrong. We've totally got the calculations wrong. So they then withdraw their case, perhaps before the inquiry. That's a paradigmatic example of when costs would be awarded. I'm not saying they would always be awarded. There may be good reasons why they made the mistakes in the first place. That mistake might be because they'd relied upon evidence by the applicant, now appellant, as to what the dimensions would be, which were wrong. But if it was their mistake, they might have withdrawn it, or so the experts rate they might have withdrawn it. That would be a paradigmatic case of costs. So to answer my Lord's questions, that's what Mr. Parsons would have been imagining ought to have been done in this case.
Yeah. There is also, isn't there, a difference between what is proper to have done
Absolutely.
and what is unreasonable not to have done?
Entirely agree. Entirely agree, my Lord. And in my respectful submission, it was open to Mr. Parsons to conclude that it was unreasonable for the council to have called evidence which was so fundamentally flawed that it collapsed under cross-examination. You didn't need to know the detail of what and what wasn't put. That could have been done, as I said in answer to an earlier question. Like Mr. Parsons gave the council the opportunity, as is always given in the exchange of costs applications, to explain their position.
Yeah.
My Lord, and just picking up my skeleton then on the decision letter. paragraph 18, page 5.
I'm sorry, paragraph.
18, page 5.
Thank you.
I set out there what I say is the essential reasoning of Mr. Parsons that could be derived from paragraphs 16 to 21.
Yes.
I don't intend to repeat it, but it is consistent with what Mr. Justice Fordham found was the essential reason as well. My Lord, it's to Mr. Justice Fordham's judgment I now do wish to turn, and just for 3 sections of the judgment, and with your indication that the proper focus is on the decision letter, and I entirely understand and agree with that. But this is an appeal, of course, against the order of
Yes.
Mr. Justice Fordham. If we may start, I wish to draw the court's attention to 3 sections of judgment, because the judgment below was dealing with a wide range of grounds. I think there were about 6, if I recall correctly, and we're really only dealing with one of them in this court, what Mr. Justice Fordham described as the scrutiny testing point, ground 3. That's what the label he gave this. That's dealt with at paragraph 35 onwards. I'll come to that in a moment. But if we can start with, please, paragraph 14.
Yeah.
This is where the judge analyses the reference to withdrawal without good reason. That obviously is a central policy from paragraph 34, although he notes that similar policies are found elsewhere in the procedural guidance. And then he indicates at paragraph 15 that withdrawal necessarily has a temporal element, should it have been earlier. So late withdrawal can be unreasonable, even if the withdrawal at that point has the virtue that no further wasted costs will be incurred. That's my phrasing, not his, but that's... And that analysis is relevant, and in my respectful submission, correct in this case, because the cost decision maker concluded that the council's decision to withdraw their support when they did, i.e. midway through the inquiry, was unreasonable because they didn't have a good reason for doing so.
The elaboration, as he calls it, at 15, on that point is crucial.
Yes, absolutely.
In fact,
yes.
Because although the decision maker doesn't do it, this is Mr. Justice Fordham's explanation for it.
Exactly, my lord. And I would urge that as a proper and only workable interpretation of the guidance. As I say, one could have good reason for withdrawing when you do, but not had a good reason for having got to that point.
Which then has nothing to do with withdrawal.
Well, my lord, it does, in the sense that one could have withdrawn it.
You could have good reason for withdrawal, but there could be lots of other reasons why the behaviour before that was unreasonable.
My lord, I'm sorry, I'm very sorry, I didn't know that.
What I don't understand is all of this elaboration in relation to the perfectly simple concept of withdrawal without good reason. You could have a case, as you agreed, that went all the way to the finish, but where it's decided that the behaviour was unreasonable because of the way in which it was conducted or the nature of the evidence. And so the temporal point here would apply, as it were, almost irrespective of withdrawal.
Well, with respect, my lord, I submit not, because if you were then to prosecute it to a final decision, there wouldn't have been a withdrawal, so you wouldn't be in paragraph 34 territory. No. What you'd be then deciding is whether actually this is one of the exceptional cases in a called-in inquiry that you should be awarding costs on the substance, because you've come to a judgment that the evidence that was called and the position that was adopted was untenable.
A party has behaved unreasonably.
Exactly, the central call.
So, yeah.
The second section I'd like to draw the court's attention to is at page 32. This is in a review finding point. This was ground 2 below. And at paragraph 30, Mr. Justice Fordham sets out what he says are the key features of the circumstances which combined to support the conclusion that the decision to withdraw their support for the application when they did was unreasonable. And I just ask you to read 31, 2 and 3. And as I say, that's consistent with my reading of the decision letter as I set out in the skeleton argument. The third section is at page 34. This is the bundle, paragraph 35. That's the scrutiny testing point. That's ground 3 below. That is, in essence, the same ground that is then renewed before this court. One can see that, although my own friend, understandably, and I don't criticise them for this, has developed submissions to some degree, they fall within the ambit of this ground, and that's the ground on which permission was granted by my lord. And the paragraph 36, Mr. Justice Fordham summarised Mr. Hunter's argument, which I say have echoes of what's been said today, and then paragraph 37 is Mr. Justice Fordham's conclusions in respect of that. And I would obviously ally myself with those. What I should say is that my lord, on the point about the apparent inconsistency in the decision letter as to whether there'd been any changed evidence, that was formed a separate ground of challenge below. That's dealt with at page 33.
What is it that Mr. Justice Fordham is saying in paragraph 37 that the council ought to have done but failed to do so? He accepts no coaching. He
Right.
accepts there were discussions.
Yes.
So where in this paragraph does he say, well, this is what the council should have done, and it was unreasonable for them not to have done it, whatever it was?
He doesn't, because that's not with respect to the function that Mr. Fordham was undertaking.
All right, well, let me go a stage back. Where in the decision letter do we find Mr. Parsons saying, this is what the council ought to have done, and not to have done it was unreasonable?
He does it in this way. He says they ought to have called evidence that stood up to scrutiny.
Well, I don't know what that means.
What it means is it doesn't collapse under cross-examination. And that they had the opportunity to provide answers as to whether, a clear answer whether they'd been changed, and those answers didn't satisfy him. He didn't identify a specific, you should have put this line of questioning to. I accept that. He didn't need to, in my respect. It was enough that he said it was unreasonable of a party to a planning inquiry to call evidence in respect to the sole issue on which the inquiry was really being convened, or the central issue, I should say. And not be able to see that evidence through to the end, because that evidence has collapsed under cross-examination.
Yeah.
And he gave the opportunity to the council to explain, or there was at least an opportunity to do so, and he wasn't persuaded by their reasoning. That is the nub of what he was saying in this case.
But just to go back to the judge's pudding metaphor, there is a large dose of ingredient of hindsight in his view that the collapse meant that it was unreasonable to put the evidence forward in the first place.
The question, I don't demur from that proposition's generality. The question is, does that render the judgment unreasonable?
Yes,
In
for which you can't apply hindsight. You can't reason backwards from the fact that an expert makes concessions in cross-examination to a conclusion that it was unreasonable to put forward that expert with that proof of evidence.
my lord, you can, in my respect, start from that position, because in the vast majority of cases, even where expert evidence is knocked down a peg or two or not accepted because of skillful cross-examination, in the vast run of cases, you don't have expert evidence withdrawn on the stand. So you can start from that as a starting point.
Right.
You can then ask, is there an explanation for that? Is there new evidence that's come up so that when the cross-examination was put that you couldn't have possibly known? Had the points been put to the witness before, is there an explanation for it? There may be factors which justify explain the council's position such that it is judged not to be unreasonable. But in my respectful position, it can be a starting point that where there is a collapse, the party calling that evidence can be fixed with costs.
Yes.
My lord, sorry, I was just making the tangential point because of the question my lord asked about the inconsistency. This is page 33 of Fordham's judgment, the change evidence point.
Yes.
As I say, this was a separate ground of challenge below, but there was inconsistency that was dealt with by Mr. Justice Fordham. An appeal wasn't brought on that particular ground. I say there's a good explanation for it. There wasn't inconsistency for the reasons I've already given, but there's also a procedural point here that was a separate ground of challenge below, and there wasn't, as I recall, any an attempt to seek permission in respect to that ground. My lord, turning to my submissions, although you have heard the vast majority of my submissions, and that's how these things go, and the fault is entirely mine. But to attempt to try and give them some structure, and without at least unduly repeating myself, could I ask you to turn your attention to paragraph, page 13 of my skeleton argument, paragraph 44 onwards. What I do in these paragraphs, from 44 through to paragraph 60, is to advance 6 submissions which address the various ways that I'd understood Mr. Hunter to say that the reasoning of Mr. Parsons' decision is demonstrably flawed. I'll run through them briefly, and we've covered much of this ground.
Yeah.
I then go on to give 2 policy reasons why, in my submission, parties to a planning inquiry should, in an appropriate case, be held liable in costs should their expert evidence not stand up to scrutiny in a sense of completely collapsing. I should stress those policy reasons. Sorry, my lord.
Where are you now in your skeleton?
I'm at page 13, paragraph 45.
45. Right.
So the 6 submissions. The first, at paragraph 45, is that his reasoning is consistent with the objectives of the cost regime in planning cases. I don't need to reiterate that. I've taken you to the PPG, and I've made the point that in planning cases of this type, evidence is almost invariably given by experts. And therefore, how does one test whether the case stands up to scrutiny other than testing the evidence of those experts, and where that expert evidence is so fundamentally flawed that it's withdrawn, it doesn't stand up to scrutiny in any sense of the word. The second is at paragraph 47, that Mr. Parsons' reasoning is not antithetical to the fault-based nature of the cost jurisdiction in planning. And to make good that proposition, we know that Mr. Parsons was aware in planning inquiries that parties ordinarily bear their own costs. he was fully aware of the guidance in respect of calling inquiries, and he applied that guidance. This is not a case where one expert witness evidence was preferred over the other, and the decision maker is imposing a de facto cost followed the event approach. As Mr. Justice Fordham said, this is a case of a collapse.
Yeah.
Thirdly, and this is at paragraph 40, Mr. Parsons did not treat the errors or failings of the expert ipso facto as errors or failings of the council. And this really, as I understand it now, is the second way in which Mr. Hunter puts his case. In other words, Mr. Parsons did not proceed on the basis it was axiomatic that once the expert's evidence had collapsed, and with it their case, the council would be held liable for costs. As Mr. Justice Fordham recognised, notwithstanding the collapse, the council were given the opportunity to explain whether they had a good reason for withdrawing the support for the application. And that opportunity was within the series of cost representations. And Mr.
Well, actually, I think what you really mean is that they were given an opportunity to explain why it was not unreasonable to have gone on with the case until Mr. Hopwood's changing.
Absolutely, my lord. That's a much clearer and more accurate formulation of what I was intending to say. Yes. Why it wasn't unreasonable not to withdraw earlier would have been a way of putting it. Absolutely. They were given the opportunity to explain why it wasn't unreasonable in light of the collapse to have withdrawn earlier. And Mr. Parsons found in paragraph 18 that the council had not explained in clear and precise terms the responses given by Mr. Hopwood in cross-examination that caused them to change their position. Obviously, my lord knows...
That obviously means something completely different to the point my lord put to you, which you agreed was a much clearer explanation. We've been over that. The not explain why the detail in the responses caused them to change their position. Well, we know precisely why. The point is why it was not unreasonable for them to continue until that point, which is a completely different question in my opinion.
Well, my lord, my respectful suspicion, no, because say the answer, and I...
Because then you're scrutinising not from the question of the cross-examination, but you're looking at the period earlier. What was the position then?
You are, my lord, but as I don't wish to repeat myself, but had hypothetically the council said, well, those points Mr. Kimberlin put, we put precisely the same points. He told us a completely different answer. That might have persuaded the decision maker that there was a clear reason why it wasn't unreasonable to withdraw until they did. They don't go that far. So the point being is that Mr. Parsons didn't treat as axiomatic the fact that the expert evidence collapsed, that the council would be fixed with the costs. Fourthly, this is paragraph 50. That reasoning doesn't impose an unrealistic or unreasonable standard on parties to ensure expert evidence withstands cross-examination, and this appears to be the first ground of challenge. Mr. Hunter argues, paragraph 52 of his skeleton, that the council does not, or at least should not, be affixed with the responsibility to ensure or be satisfied that their expert witness evidence would withstand cross-examination. Now, I say that the judgment Mr. Parsons reached that there was an onus on the council to ensure that their evidence would withstand cross-examination is consistent with both the guidance, which I've taken you to, about parties being the object of the cost regime is for parties to substantiate their case, but also the case law interpreting that guidance, which suggests that there is an evidential threshold of respectful basis for the stance on a particular issue, that if they go beyond, it's unlikely they're going to be awarded costs. So that's in particular, the Wakefield case, Mr. Justice Jarrett's Secretary of State case. And in this case, ultimately, the expert evidence called on behalf of the council didn't reach that evidential threshold. We know that because they withdrew their case in light of it. And so the onus that Mr. Parsons is putting on the council is not an improper or, in my respectful submission, unlawful onus. It's an onus which is consistent with the guidance and with the case law interpreting that guidance. Fifthly, and this is paragraph 53, this is an argument that was advanced with more force below. I don't think my learned friend puts it as strongly now, but below it was said that the onus would be entirely inconsistent with the witness's professional obligations. Now, I make it plain, as I did below, that parties to planning inquiry clearly cannot rehearse, coach or direct evidence. Nothing which I am about to say should be taken as said to undermine that. But it is perfectly proper for parties and their representatives in the lead up to the planning inquiry to test the strength of the expert evidence before submitting it and having it subject to cross-examination. And as I said in answer to question before, that happens at virtually every planning inquiry. In fact, if a barrister didn't do that, it might be suggested that you were not acting appropriately in the interest of your client. That is consistent with the professional guidance which Mr. Justice Fordham cites and which I have cited in the skeleton argument. I'm not going to take my all through it, but it would have been perfectly proper and open to the council to have tested Mr. Hopwood's evidence, including using the themes that Mr. Kimblin eventually did.
But again, you need to go further. You need to go further and say it would have been proper for the council to have done this. You need to say it was unreasonable for the council not to have done this.
With respect, I don't, because it's not for me to say it was unreasonable, it's for me to say that the judgment of Mr. Parsons that it was unreasonable is not irrational. And the point made against me, and particularly pushed below, is that there was a demonstrable flaw in Mr. Parsons' reasoning, because he was asking parties to do what they can't do, consistent with their professional obligations. Yeah. And I'm saying, no, that's wrong.
No,
they couldn't.
But it's not enough for Mr. Parsons to say they could have done this.
No.
He doesn't. He says they should have done it. Yeah. So in pointing to this professional guidance, which says you can do it, doesn't support the proposition that it's unreasonable not to.
It supports the proposition that there's no demonstrable flaw in Mr. Parsons' reasoning.
Not in saying that you can't discuss matters with the expert.
No. But we've gone across over his essential reasoning, which I won't reiterate. This is in effect a responsive point that I'm making to a point that I thought certainly was made strongly against me below, and I think it's been probably maintained, but not the same force perhaps in this court. I have to say, my lone friend introduced the case of Ultraframe. I won't take my Lord Justice Coulson was obviously the presiding judge in that matter, and obviously
I was actually.
Oh, I'm sorry, my Lord.
Right.
Lord Justice, was it Lord Justice Lewison? I'm so sorry. I've got my
burned in my memory.
It was. So sorry.
That's good because it wasn't burnt in mine.
I'm very, very, very sorry. But you declined, you'll recall, my Lord, to give general guidance on witness training in civil cases there. And in my respectful submission, nothing that's said in there cuts across anything. I'm now going to move to the sixth proposition, which is the at paragraph 59, and in respect of the criminal cases and what assistance they give. And I submit that they do not establish, even by analogy, the principles to be applied in planning cases in respect to the award of costs. My Lord, that is likely to take me more than the 7 minutes or so we've got, but are you happy for me to launch into that at the moment?
Which would you prefer to do? Do you want to have 5 minutes, 6, 7 minutes doing it now, or do you want to come back at 5 to 2?
I'd prefer to come back at 5 to 2 if that were acceptable to the court.
Right. How much longer do you think you're going to be?
Not much longer. This is my last main submission. I've got 2 policy reasons, and I've got to deal with adequate reasons, which won't take very long. I suspect half an hour at most.
Half an hour. All right. And Mr. Hunter, you envisaging a reply?
Yes, at the moment, about 10 to 15 minutes.
All right. We'll come back at 1:55 then.
Court rise